The first component of an abolition bill is that it abolishes abortion from conception. All right, so most, or just about all pro-life bills, they're going to choose some arbitrary point at which they're going to protect preborn children. So they're going to choose 20 weeks or 24 weeks or 8 weeks or 15 weeks. But abolitionists, we believe that there is both a biblical mandate and a constitutional mandate to say life begins at conception, and we're abolishing abortion from that point forward. And so scripturally, if you read through the prophets, one of the first things on their lips almost always is justice, right? People are turning a blind eye to the shedding of innocent blood, and this has got to stop. We've got to establish justice. And not just in the Old Testament. If you look at Luke 11, what does Jesus say to the Pharisees, right? He says, woe to you, you do all these religious things, you want people to think you're super duper religious, but you neglect what? You neglect justice and mercy. And so justice is a very important biblical concept, and not just justice generally, but I think God's word speaks very clearly to how we are to establish justice. If you look at something like Isaiah 10, it says, woe to those who decree iniquitous decrees, and the writers who continue writing oppression into law that make the fatherless pray. And so when you look at a pro-life bill, like you could argue that a 20-week ban is less iniquitous than the status quo. You could say it's less iniquitous than a ban at 24 weeks or something, but you can't argue that it's not iniquitous. It is iniquitous to either explicitly or implicitly recognize the right to murder children up to 20 weeks is iniquitous. And so, a pro-lifer might say, well, we're trying to do this because it might do some good, even if it's not all the good. Well, God's word also says in Acts, right, never do evil that good may come. And so we can't have a strategy of calling for or writing or supporting iniquitous laws and have that be the basis for our strategy. We've got to put forward a just, righteous, godly standard and say, this is what we're calling for, and call people to meet that standard, right? Life begins at conception. So not only is there a biblical mandate to establish that life begins at conception, there's a constitutional mandate. If we look at the 14th Amendment, right, it says, no state shall deprive any person of life, liberty, or process, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law, right? So we've got our inherent unalienable right to life and inherent unalienable right to the equal protection of the law. Now, what the Supreme Court did and what a lot of abortion supporters will do is they'll say, well, people or person doesn't include all human beings. Right, and I think this is just a really preposterous idea. The entire point of the 14th Amendment, right, this was part of the abolition of slavery. And so the entire point here was to say that never again will there be a class of human beings who are denied the rights of personhood. Right, all human beings are deserving of the equal protection of the law. All people are deserving of the equal protection of the law. And if it's possible to say within this amendment that there can be a certain group of human beings who are going to exclude from the rights of personhood, if that's possible, then the 14th Amendment doesn't do anything. And any one of us can be enslaved or denied the equal protection of the law or killed or anything. Right? If the 14th Amendment doesn't protect all human beings, it doesn't protect anyone. And so I'm not going to go too much further into this, but there's a guy named Josh Craddock, who's a friend of mine. He's written a really good paper in the Harvard Journal of Law and Public Policy entitled Protecting Prenatal Persons, Does the 14th Amendment Prohibit Abortion? And so if you want more on the topic of the 14th Amendment, that's where I would recommend you to. It's a really good paper. He's a really smart guy. He was the editor-in-chief of that Harvard Law Journal. And so I highly recommend that for more on that topic. And so that's component one. An abolition bill abolishes abortion from conception. Now, component two is no exceptions. And what I'm going to do real quick is I'm going to go through the three exceptions that are the most common exceptions that pro-life people will include in their bills. So the first one is babies conceived in rape. The second one is babies conceived in incest or with disabilities. And the third one is the life and health of the mother. So let's start with babies conceived in rape. Now again, the equal protection of the law must be given to all people, right? There's not an exception there for, babies conceived a certain way. Now, women who have this done to them need the support of their families and their communities and all that stuff, and I personally believe that rape should be a capital crime. I mean, this is a serious, serious crime, and people who are victims of it need the support of their communities, but that doesn't mean they should have the right to murder another human being, right? I believe we should punish the rapist to death for that crime, but we cannot punish the child to death for the sins committed by the father. That's fundamentally unjust, and we should not tolerate this exception in our legislation. Next one, disabilities and incest. So again, like there's a lot of people walking around who have disabilities, right? It's not all that uncommon. And what a slap in the face it is to people with disabilities when we write into our laws that it's okay to murder people like you, right? It's so obviously unjust. It's really surprising that people still hold on to this to this exception, but it really is just really obviously unjust. And hopefully pro-life people are beginning to see that more and more. The third one is life and health of the mother. So this one, it's important to separate those two concepts, life and health. So let's deal with the first one, which is health of the mother. This one has to be just dismissed out of hand because in the Doe v. Bolton case, the Supreme Court explained what they meant by health of the mother. And what they meant is anything, right? It can be familial health, economic health, right? Emotional health. Health is basically code in Supreme Court terms for anything. And so it basically covers any excuse for abortion. And so we can, if health of the mother is in a bill, we cannot support it as an exception because it means virtually anything. Now, life of the mother, you got to treat it in a very nuanced way because it is a real situation. There are life-threatening complications in pregnancy that really do occur. Now, the key is to define our terms correctly. And so the role of a doctor is to preserve as much human life as possible, and that cannot ever change no matter what the complication is or anything. And so if there's a life-threatening complication, it's most often going to happen later in the pregnancy, right? And that's at a time when a doctor can, terminate the pregnancy by delivering the child, right? And it's usually even the safest way for the mom, right? And so we can solve that life-threatening complication through the delivery of that child. There's no reason to kill them and then deliver them. Now, if we're early on in the pregnancy, ectopic pregnancies are a real thing, right? That is a real thing that occurs, and it's a very tricky thing to deal with. But it's very important we don't define the treatment of an ectopic pregnancy as an abortion, right? Abortion is the intentional killing of a human being. Now, if there is an ectopic pregnancy, and that actually usually it's a moot point because the child will have passed before the ectopic pregnancy is even discovered. But if the child is still alive, again, you're not justified in going in and pulling that child out one limb at a time, piece by piece. However, you can deliver the child early, right? You can go in and you can cut out either a piece of or the whole fallopian tube and deliver that child. And as Kelly Green, who was going to be here today, but he just saw the birth of his fourth child, as he put it very well, the doctor must maintain a Hippocratic disposition toward all patients involved. And so you're not justified in going in and tearing that child apart and pulling them out of the womb. But there are circumstances where you have to deliver that child early, knowing that they're almost certainly not going to survive. And that's a tragedy, but it's not an abortion. And it's important that we don't define that as an abortion because there are parents who tragically have to deal with this. And what are we saying to them if we're saying that's an abortion? We're saying you did the same thing to your child that someone who walked into an abortion clinic willingly did to theirs. So you're guilty of murder. And so it's very important that we separate those two things. Like pro-aborts will want to conflate the two. They'll want to make sure there's not a stark line between healthcare and abortion, because that's their whole project, right? Saying that abortion is healthcare. But we've got to draw a very stark line between what is a good faith treatment of both patients and what is the intentional destruction of a human being. And the treatment of ectopic pregnancy is not or should not be defined as an abortion. And so because of that, we don't need an exception for the life of the mother. We just need to define abortion rightly, both when we're talking about it in the culture and in the laws that we write. And so that we should not treat that as an abortion. So that is component 2, no exceptions. Component 3, equal protection. So this one is a very tricky one for a lot of pro-lifers because it is a very common pro-life dogma that the mother must be immune from prosecution in all cases of abortion. And I'm going to give you 3 reasons why this is not good policy to give automatic immunity to mothers who have their children murdered. So, point 1, failing to provide equal protection protects do-it-yourself abortion. Right? So if we're going to say that the mother is immune from penalty, what we're essentially saying is that she has the right to murder her child. Right? That is the effect of that policy. And now I want to read to you a quick quote from a 2019 New York Times article that was written by a board member of the National Abortion Federation named Carrie Sietstra. So she writes, "We can work to fully decriminalize self-induced abortions. This is an area where all Americans, including pro-life Americans, can work together. The pro-life movement has insisted for decades that women should not be prosecuted for self-abortion. Now, of course, Carrie Siestra advocates for legal abortion. She's doing something very, very evil. But here, she's right. She's saying the pro-life movement is insisting that women should not be prosecuted for abortions, and so basically they're with us on the idea that self-induced abortion should remain legal, and so we should be able to work together to keep it legal, is what she's saying, and basically she's right, and that's a really, really awful consequence of what the pro-life movement is arguing for. Now, this is especially damaging because the abortion industry is evolving quickly. Abortions are becoming earlier and earlier, and they're not as often happening in abortion clinics. They're often happening in homes. I mean, you can go to websites and order pills straight to your front door with instructions on how to do it and when to take it and all that stuff. And if we're going to say that women are immune in all cases, there's nothing we can do to prevent that from happening, right? That's perfectly legal under pro-life laws that give women immunity in the murder of their children. So the first reason why we must not give immunity, why we must give equal protection to all preborn children, is because failing to provide equal protection protects self-induced abortion. Reason 2, penalties are deterrents. And so before I get into any commentary of my own, I want to read 2 quick quotes. These were from, we had a conference in Oklahoma in 2020, and we gave the stage to a couple of post-aborted mothers. And here's what they had to say. This is Jill Robbins. She's an abolitionist from Texas. And she says, "If only abortion had not been an option, how different things might have played out for my life, and for sure for the life of my child who didn't get the chance to live his life. Righteous laws restrain evil behavior." Along the same lines, Cheryl Calley, also an abolitionist from Texas, she said, "If I were not exempt from being prosecuted for murdering my own child, I would not have gone into Planned Parenthood at 15 years old and killed my baby." The reason pro-lifers give for wanting immunity for the mother is because they think it's more kind, it's more compassionate, right? There is nothing compassionate about leaving the option to murder your own child on the table, right? The compassionate thing to do for Jill and for Cheryl and all the people who are considering abortion or who used to consider abortion, the most compassionate thing that they need is a law that guides them away from the wickedness of murdering their own child. That's the compassionate thing to do. Leaving the option for them to self-induce their own abortion, there is nothing loving, nothing compassionate about that. All right, we've got to protect people by using the law to guide people away from choosing evil things like murdering their own child. That's one of the most important functions of the law, right? To be a tutor, to teach people that this is wrong and we should not do it. And so penalties are a deterrent. It's not as if there's still going to be 1 million abortions every year in America, and we're going to be throwing 1 million mothers and fathers in jail. No, people aren't going to choose to do this in most cases if it's actually classified as homicide, right? And post-abortive mothers and fathers testify to this. And so that's the second reason why we must not give automatic immunity to the mother in all cases. The third reason is because the Roe v. Wade decision actually largely relied on the lack of equal protection in the pro-life Texas laws. And so I'm going to read to you, this is what Dale alluded to earlier. This is footnote 54. So this is a piece of the Roe decision itself. Justice Harry Blackmun, who's the author of the decision, writes, "There are other inconsistencies between 14th Amendment status and the typical abortion statute. It has already been pointed out that in Texas, the woman is not a principal or an accomplice with respect to an abortion upon her. If the fetus is a person, why is the woman not a principal or an accomplice?" So essentially, what he's saying, so the state of Texas was arguing the pro-life position in this case, and they were saying, look, the 14th Amendment says equal protection for all people. And the court came back and said, well, if that's true, if the preborn child really is a person like you're saying, then why does the woman have full immunity to murder her own child? Right? There's something inconsistent there, and you're showing, you're tipping to the fact that you don't really believe that this is a person. And he continues. Further, the penalty for criminal abortion specified by Article 1195 is significantly less than the maximum penalty for murder prescribed by Article 1257 of the Texas Penal Code. If the fetus is a person, may the penalties be different. So again, what he's saying there is that you classify abortion as something other than homicide, right? As Dale said, as murder light. you're not really treating it like murder, because the penalty for Texas for abortion, there was no penalty at all for the mother, but even for the abortionist, it was 2 to 5 years for an abortion back before Roe. And so what Blackman is saying is, if this is murder, and if this child in the womb is a person, how can it be 2 to 5 years, right? How is this classified as something other than murder if that really is a person, right? And so the consequence of being inconsistent is Roe v. Wade, right? Roe v. Wade is the consequence of the pro-life laws not consistently treating the preborn children as human beings. And so again, we don't have that difficult of a position to defend. Like the pro-lifers will say, oh, you guys hate women because you think, that they should be liable to be prosecuted in some abortion cases. Our case is not prosecute women. Our case is equal protection under the law. Every human being should be made equal under the law. There's nothing in an abolition bill that says, the woman must, or the mom or the dad must get first-degree murder charges. All an abolition bill does is say that preborn children are equal to born children, equal to all of us. That's all an abolition bill says. And so the pro-lifers or the pro-life leaders at least, will make it sound really, really kind of nefarious and mean, but all we're saying, our simple demand is equal protection of the law to all human beings. And so that's the third component of an abolition bill, is equal protection. Now, component 4 is ignore Roe. And so again, I think with this point, I think we have a biblical mandate involved in this, and I think we have a constitutional mandate involved in this. And so let's touch on the biblical argument first. And I think I might speed through this, because I think Dale already touched on this stuff and did a really, really good job with it. But basically, there are lots of examples in Scripture, right? You've got Exodus 1 with the Hebrew midwives. You've got Daniel 3 with the Shadrach, Meshach, and Abednego saying, no, we are not going to bow down and worship an image of Nebuchadnezzar, and you can throw us in the fire, do whatever you want. We're not going to do it, right? We're going to defy this idolatrous order from the civil authorities. And then Acts 5, again, you've got preachers of Jesus Christ being told, stop teaching in that name, and they say, no, we must obey God rather than man, right? Where God's law and man's law conflict so blatantly. It's hard to get more evil than the Supreme Court telling the states and the other branches of the federal government allow genocide, right? It's hard to conflict with God's law more blatantly than that. And so I think we don't just have a biblical right, I think we have a biblical mandate to say no. In our state, in Arkansas, in Oklahoma, in Texas, wherever it be, we are not going to go along with this. We're not going to allow the mass murder of preborn children. So I think we have a biblical mandate, not just a right, but a mandate to ignore Roe. Now, constitutionally, I also think we have a mandate to ignore Roe. So I talked about Josh Craddock earlier, who is an anti-abortion legal scholar, and I've gave some commentary myself, but I also want to talk about or cite some people on the other side of this, just to show how universally agreed upon it is that Roe is an absurd legal argument and legal decision. And so this is the former dean of Stanford Law School, John Hart Eli. And this is someone who supports abortion as a matter of policy, but this is his commentary on the legal legitimacy of Roe v. Wade. He says, Roe v. Wade is not constitutional law and gives almost no sense of an obligation to try to be. That's pretty crazy. He's not even saying Roe's wrong. He's saying the court barely even tried to hide the fact that they were just making up a right that's not in the Constitution. Right? He's saying they hardly even tried to make it appear legitimate. That's how bad the Roe v. Wade decision is. One more quote from Edward Lazarus, who was a close friend of Roe author Harry Blackman and a clerk of Harry Blackman. And he says, again, this is someone who is a progressive. He says, as a matter of constitutional interpretation, even most liberal jurisprudence, if you administer the truth serum, will tell you Roe is basically indefensible, right? So it's universal agreement. Roe is not in accordance with the Constitution. And so the question then becomes, what do we do with when the Supreme Court tells us to do things that are blatantly against the Constitution? Must we submit unconditionally? No matter how evil, no matter how unconstitutional, must we submit unconditionally? I think anyone who has taken basic civics class knows the answer is no. We have a system of checks and balances, and when one branch of government goes outside of its rightful bounds, outside of its rightful authority, it's incumbent on the other branches to check them. right? Now, when we talk about checking the Supreme Court, there's two options at our disposal, or not even the Supreme Court, but the judiciary in general. There's two options at our disposal. We've got ignore it, right, and say, nope, I appreciate that you're saying this, but the Constitution tells us to do something else, to protect the right to life, or you can impeach them, right? Now, neither of these are practiced very widely because judicial supremacy is so ingrained in the culture. And so we've got to uningrain that. We've got to show people the biblical arguments for defying the Supreme Court, the constitutional arguments for defying the Supreme Court, because it's not radical, right? To uphold the Constitution in defiance of the Supreme Court is not a radical idea in reality, but it's perceived that way. And so we've got to make these arguments consistently, the biblical argument, the constitutional argument, and we've got to undo the judicial supremacy that is so ingrained in our culture. One other point on this, and then this is just kind of a quick thing you can tell people on this. No public official takes an oath to uphold and defend the Supreme Court, right? They take an oath to uphold and defend the United States Constitution against aggressors upon it, either foreign or domestic, right? It sounds crazy, but if you think about it, it really is just undeniably true. The Supreme Court is an aggressor upon the U.S. Constitution. They are saying the right to murder children is in the U.S. Constitution. Right? They are attacking the Constitution. And so it is incumbent upon state legislators, state judges, governors, state attorney generals to stand up against them. It is incumbent upon them to uphold the Constitution in defiance of Roe v. Wade and the Supreme Court. So one other thing I want to talk about on this fourth component of an abolition bill is I want to talk about the pragmatic case for ignoring Roe. So pro-life politicians, like in Oklahoma, we had a senator, an anti-abolitionist senator last year, and he had a pro-life bill, and he said this bill is going to save thousands of lives every year, right? And you may have seen that here in Arkansas or elsewhere. That's what they say. They say these laws save thousands of lives, right? It's not true. It's not true, and I can demonstrate it fairly easily. So in the Planned Parenthood v. Casey case in 1992, the Supreme Court kind of made some clarifications to Roe v. Wade, and in it they said that no law that provides an quote-unquote undue burden on the right to an abortion can be upheld. So what that means is that any law, for it to be upheld in court, has to not provide an undue burden on the right to an abortion. In other words, it has to do basically nothing. Right? And so if they pass a law that is an undue burden, it actually would save a few lives or a few hundred lives or a few thousand lives. If it actually did do that, it's going to be struck down. And if it is not going to do that, then it can be upheld, but it's not going to do anything. Right? And so we're kind of trapped in the situation where unless you ignore Roe, you can do nothing about abortion. You must start with ignoring Roe. So pro-lifers will often cite the decreasing abortion numbers since about 1992, and that's true. Abortion numbers have gone down since about 1992. But guess what? They're not only going down in pro-life states. They're going down at roughly the same rate in Arkansas and Oklahoma and Texas as they're going down in California, Illinois, and New York. All right? The rate of decline between pro-life and pro-abortion states is not significant at all. I mean, here at Arkansas, I think you guys were, in 2019, the most pro-life state, right, by Americans United for Life, and abortion went up from 2017 to 2018, right? And so these pro-life regulations are not doing anything substantial about abortion. Unless we ignore Roe, we can't do anything substantial about abortion. One other point here, abolitionist of slavery Frederick Douglass put this really well. He said, "Power concedes nothing without a demand. It never has, and it never will." So the Supreme Court has usurped power, right? They have taken power that belongs to the legislative branch, right? They have no ability to create rights, like the right to an abortion, but they did it anyway, right? They've taken power for themselves that isn't theirs. They're not going to give that back unless we take a stand, unless we make a demand of them, right? And so the pro-life, the posture of the pro-life politicians and organizations is unconditional submission. And that may sound harsh, and maybe if you guys aren't super familiar with abolitionism, that may even sound conspiratorial, or like I'm making them sound bad when they're really not that bad, right? But Joe Poyman, right, the director of Texas Alliance for Life, he told the Houston Chronicle 2 years ago, as he was opposing the bill to abolish abortion in Texas, the director of Texas Alliance for Life told the Houston Chronicle, "We could no sooner ignore SCOTUS than we could ignore the force of gravity." Right? He's equating SCOTUS's authority over us with a law of nature, right? That is the posture of the pro-life organizations and politicians toward the Supreme Court and Roe v. Wade. That is their posture. And when you take that posture, the Supreme Court does not fear you. You know who the Supreme Court fears? Abortion supporters, right? Pro-abortion district attorneys and attorney generals have put together a statement saying that if abortion is abolished, they're not going to prosecute people who have abortion. They're saying we will nullify anyone or any law or court opinion that purports to abolish abortion. That's their posture toward the Supreme Court and the federal government. And the Supreme Court fears them because of that. But they don't fear pro-lifers. To this day, one of the most incredible videos I've ever seen on the internet, after the Planned Parenthood v. Casey Supreme Court decision, right, crushing blow to the pro-life movement. So they had an 8-1 Republican majority on the Supreme Court that year. 8-1, 8 Republican-appointed justices. And the one Democrat was pro-life. He voted against Roe. So you have a pro-life Democrat and 8 Republicans. This should have been a slam dunk overturning of Roe. Should have been slam dunk, and they didn't. They upheld Roe v. Wade. And this guy, Gary Bauer from the Family Research Council, stands in front of the Supreme Court and says this is a great day for women and unborn children. Right? They had this. They claim victory even when they're delivered the most crushing defeat. Right? And so the Supreme Court knows they can rule against preborn children as many times as they want, and the pro-lifers will never, ever push back in any significant way. They will submit unconditionally. They'll pretend they're winning as the Supreme Court reaffirms Roe v. Wade. And the Supreme Court does not fear the pro-life movement because of it. Now, abolitionists are changing that. We are putting bills forward in 12 states now to abolish abortion. Attorney Bradley Pierce of Abolish Abortion Texas and the Foundation to Abolish Abortion has written an amicus brief in the Mississippi 15-week abortion ban case that's going to be decided in the middle of next year. And he has given the abolitionist perspective, and he has basically told the Supreme Court, either you abolish abortion or we're going to do it without your permission. And Free the States and Abolish Abortion Arkansas and OSA and I believe 20 organizations have signed on to that amicus brief. And the Supreme Court now knows that there is a growing movement of people who are going to abolish abortion with or without them. That is making a demand. Right? We're not submitting unconditionally. We're making a demand. And the Supreme Court is not going to give back the power that it usurped until enough people are making that demand, until they feel enough pressure. And so it's time to stop taking this posture of unconditional submission. It's time to start making demands of the Supreme Court. And that's one of the reasons why it's so important to call for and to support legislation that ignores Roe. The fifth and final component is that an abolition bill repeals or supersedes all contradictory pro-life laws. Now, this is a hard one for a lot of pro-life lobbyists. I don't know if you guys have seen, there's a video on the internet on YouTube of my colleague Russell Hunter and Rusty Thomas and Lindy Silk talking to Oklahomans for Life lobbyist Tony Lounger in the halls of the Oklahoma Capitol. And in that video, Tony Lounger, the pro-life lobbyist, he says, your abolition bill, it gets rid of all of our hard-fought pro-life victories. Those laws are worth preserving. Now, the problem is you can't have a law saying abortion's homicide, it's completely abolished, coexisting with other active laws which either explicitly or implicitly recognize the right to an abortion in certain circumstances or up to a certain point. Right? You have to either repeal them, take them off the books, or make sure they're not active any longer. So you've got to repeal or supersede them. Now, a lot of the pro-life lobbyists, it's a hit to their pride because those laws are what they fought, that's their legacy. And so it is a hit to their pride in a lot of cases, but it's not anything worse than that. You know, these laws have to be repealed or superseded in order for abortion to actually be abolished. So those are the 5 components of an abolition bill: abolish abortion from conception, no exceptions, equal protection, ignore Roe, and repeal or supersede all contradictory pro-life laws. And so this is kind of the standard for judging, which bills are actual abolition bills and which bills are kind of pretending to be abolition bills. Like you guys had SB 6, here in Arkansas. In Texas, Texas Right to Life is calling their bills and their strategy the Texas Abolition Strategy. Right? Again, the pro-lifers are seeing the momentum that we have building in Arkansas, Texas, Oklahoma, all these states, and they want a piece of it. They're trying to use our language to kind of trick people into thinking that they're the real abolitionists. But we got to use this standard to judge whether or not a bill is actually an abolition bill.